Good afternoon.
Good afternoon, Your Honor. The reset date for the next SAP calendar is going to be September the 10th.
Okay. All right, we'll get started. Good afternoon, ladies and gentlemen. We're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's Office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible plea arraignment, and a possible plea offer if one has been made at this juncture. Want to also remind you that the SAP reset date, as was previously stated, is September the 10th. I want to also begin by advising everyone that this whole entire proceeding is being recorded and live streamed on YouTube. So govern yourselves accordingly. I want to remind the defendants on this calendar that you do have certain constitutional rights. You have a right to counsel, and you should know who your attorney is at this point. You also have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be used against you. The state is here and they're listening, so please follow the lead of your attorney when it comes to this proceeding. Who do we have first, deputies?
We can start with position number 17, Mr. Reynolds. And that is in courtroom 1.
Okay.
Thorough. Sir, I just told you no talking when court starts.
This is 24 CR 006066C. C is in cat. This is Emery Reynolds, charged with 1 count of battery family violence. Pre-trial?
11 total, 2024 DUI. His previous violent charges were dismissed.
Okay.
I don't know what's with this camera. Goodness.
That's my case, Your Honor. This is an incident that happened on August the 27th between 2:30 and 3:15 a.m. The victim in this case is the defendant's daughter. This occurred at 8601 Roberts Drive in Sandy Springs. The family and extended family were moving out of the location. The wife of the defendant, Mrs. Antonia Reynolds, reported that the defendant had been drinking. He's got a drinking problem. He becomes more aggressive, and he was doing so throughout the evening. They took away the pint of liquor that he was drinking. He became angry, and he went and woke his wife up and began arguing with her, Ms. Antonia Reynolds. His adult daughter, the victim in this case, Emily Reynolds, intervened, and the defendant punched her in her face. She was seen to have redness and puffiness and inflammation, to her left eye. They also reported that the defendant had been dropped off at the bus station and that he'd checked himself in for treatment at Northside Hospital. So police relocated there and spoke to the defendant, who said he backhanded his daughter because he didn't like the way she spoke to him. The defendant does have multiple convictions for DUIs. As indicated, there might be a drinking problem here. He has 3 different arrests for battery and family violence matters that were all either dismissed or null prossed in the past, Your Honor. We have been attempted to get in touch with the victims this morning, but have not been successful based on the criminal history and the information in the warrant, as well as the admissions. We would argue there's a risk to reoffend and a risk to intimidate and harass the victims. So we'd be asking for a $2,000 surety, Your Honor, no contact with Antonia or Emily Reynolds. Stay away from wherever they may reside. They were moving out. So I'm not sure the new address, and no drugs, alcohol, or weapons while on bond. Thank you.
Thank you. All right, PD McLean.
Your Honor, if he will just stay away from alcohol, there probably won't be any risks involved. He definitely needs to not drink. And I don't know if taking that stuff that makes you sick when you drink would be the way to go, or what else, but we would ask the court to consider a signature bond with appropriate conditions.
I'm going to order the $2,000 surety bond. With that surety bond, there'd be a stay away. I dare say 8601 Roberts Drive, since it did seem like the parties don't reside there, but there will be a provision to stay within 200 yards of the victims in this case. No further contact with Antonia or Emily Reynolds, and stay 200 yards from them. No contact by phone, cell, emails, third parties. No posting on social media about them either. Also, I'm going to order no drugs, unprescribed medication, no alcohol, no weapons or guns while on bond. I was inclined to order him to go to AA meetings. I don't know if he's been in AA or not, or if he is familiar with that program, maybe with his other convictions he has. Can you just ask him real quick, is he registered or has he been to AA meetings before?
Been there? He has.
Is he still going?
How recent? No.
All right, I'm gonna order him to go back to his AA meetings so he can get some help with his alcoholism, the problems that he has with it. I dare say 1 or 2 times a week, but at least reconvene and go back to his AA meetings.
Yes, Your Honor.
Anything
you.
else, counsel? Nope. That's it.
We can go to position number 2, Ms. Bates.
Now, should I relocate to the other place?
It's up to you. Stay.
I'm fine here.
I can tell, I'll take them back.
Mr. McLean, you're not muted. Okay. This is 24 CR 0060668B. Bridget Bates. She's being charged with 1 count of battery, 1 count of affray, 3rd count of public drunk, pretrial.
6 total. Oh, yeah. Last arrest was on the 1st of this month. Battery DV. I'm surrendering that bond. On probation for unlawful conduct during 911 call. It's 23 CR 008-256B. And an 08 simple assault conviction. I think that bond is 3,000,
Okay.
but don't quote me.
All right. State.
Yes, Your Honor. I do see that the defendant also had a 2024 FTA and a 2011 arrest for aggravated assault. This incident occurred August 27th, 2024. The defendant is accused of getting into a fight with Mary Ann Collins. The parties were in a vehicle with Miss Ethel Turner, who was driving the vehicle at the time. The defendant reached into the front passenger seat where the victim was sitting and began to strike her while the vehicle was moving. The defendant also hit the victim in the arm, bit the victim in the arm, I apologize, and struck the victim with a broom. When officers arrived at the scene, they observed Miss Turner trying to break up the dispute, and the defendant and the victim were aggressively holding each other while they were pinned to the floorboard of the vehicle. Officers were able to separate the parties, and the defendant appeared to have slurred speech. Her nose was runny. She was unable to recognize what was happening around her, and she fell face first into the concrete. The defendant did admit to having more than 1 drink that night and kept referring to the victim as a bitch who was messing with her husband. The victim did sustain a bite mark to her arm. The state's recommendation is going to be a $1,500 surety bond on the battery, a $1,000 surety bond on the affray, a $500 surety bond on the public drunk. This is based on the fact that the defendant does have an FTA. She has a criminal history that includes violent arrests and convictions, one from looks like earlier this month, based on what pretrial said, and there is a potential that she will intimidate this victim given the behavior that was exhibited in this incident. The state is also recommending no further contact with the victim, anger awareness, and no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for the victim, Ms. Mary Ann Collins.
Mary Ann Collins. Mary Ann Collins. All right, she's not here. Defense, who's PD Cook?
Yes, Your Honor. Um, my client is 52 years old, and she is currently working as a package handler for UPS. Her position is that the other two folks were the aggressors. However, given her history, we don't we find the state's recommendation reasonable, Your Honor. We would not object.
All right, I usually double it or give a cash bond when you're out on bond and you violate our orders. But
The state would not object to that, Your Honor.
right,
That might be a little tight for her budget, Your Honor.
oh, I hear that a lot. I'm going to make it a $4,000 surety bond, 2,500 on the battery, 1,000 on the affray, 500 on the public drunk. So that should be a total of 4,000, right?
Yes,
Yeah.
that's correct.
All right, I'll make it a $4,000 surety bond. Going to ask that she stay away from Marianne Collins or have no further contact with her. I don't have a stay away address, but stay away from Marianne Collins's home as well as her employment if she has it, not to come within 200 yards of her. No drugs, unprescribed medication, alcohol, or weapons while on bond. And that should be it.
Thank you.
You can have a seat, Your Honor. Next, we can go to position number 8, Ms. Hall.
This is 24 CR 006078Y, Amanda Hall, charged with 2 counts of battery, pretrial.
11 total. Last was this year, possession of cocaine and marijuana out of Pinellas County, out of Florida. What else? Got possession of meth, trespass, drug equipment is what they call it. I also see a battery from 2020, grand theft motor vehicle from 2023. Resident of Clearwater, Florida, 2022, possession of drug paraphernalia, petty theft conviction.
All right, state.
Yes, Your Honor. This incident occurred August 27th, 2024 at 111 John Wesley Dobbs Avenue, Northeast Atlanta. That is the Reflections Apartments, which is a GSU student housing building. The defendant is accused of punching Wanique King in the face after a brief verbal altercation. Ms. King was walking to her residence when the defendant told her to get those children inside the building. The defendant was referring to 2 mannequins that Ms. King was holding. When Ms. King turned around to respond, the defendant punched her in the forehead unprovoked. The defendant is also accused of striking Morgan Willingham in the head the same day. Both victims did sustain bruises as a result of being attacked by the defendant. Our office has had a chance to speak with both victims. Ms. King states that she was walking to her apartment when the defendant said something to her and then began walking up to her and then started hitting her. She says that she does not know the defendant and has never seen her before. She does not believe the defendant lives at these apartments and wants no contact and wants the defendant to stay away. Ms. Willingham stated that she was heading to class when the defendant randomly came behind her and hit her in the head. She says that she doesn't know the defendant and had never seen her prior to this incident. She also stated she did not witness the altercation between the defendant and Ms. King, and she wants no contact and for the defendant to stay away. The state's recommendation is going to be a $2,000 surety bond on each count of battery, and that is based on the defendant's numerous arrest cycles, which do include a violent arrest, as well as the fact that she has no substantial ties to the community. We are going to be requesting no further contact with the victim, stay away from the incident location, also stay away from all GSU property, as well as the GSU campus. We think either a BHET or an ADT or a social worker visit, something is going to be required for this victim, given her history and the facts of this case. The state is also going to recommend no drugs, weapons, or alcohol while out on bond. And I would ask the court to sound for the victims, Wanique King and Morgan Willingham.
Ms. King or Ms. Willingham?
Hi, Ms. King.
Do you wish to address the court today, yes or no?
Yes.
I will swear you in. Raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. Do you want to have any contact with Miss Amanda Hall?
No, not at all.
All right, and are you in fear of Miss Amanda Hall?
Yes.
Okay. All right, is Miss Willingham on the Zoom? Nope. All right. Go ahead, PD Cook.
Yes. Your Honor, we don't object to any of the stayaways or any of the provisions limiting contact. We would, given her, she's not working, so given her lack of income, we would certainly be seeking a surety bond. We understand that SOB is probably not in play here. We would be seeking a surety bond in the combined in the $1,500 range. Beyond that, we would have no other objection.
Okay. I'm going to order a $4,000 surety bond, $2,000 on each battery. I'm gonna order a stay away from Georgia State University. I assume that this defendant does not go to school there. And because these are random attacks. They have no further contact with the victims, Ms. Willingham and Ms. King. Stay away from the Georgia State campus. It's pretty vast. It's all of downtown Atlanta, just about.
Yes, it is.
So certainly stay away from the incident location, all that area that belongs to Georgia State around John Wesley Dobbs. It still may be a pretty vast area, but just want to make sure as long as Ms. Hall is not a student of Georgia State nor a resident who resides in that area, which I believe she doesn't, she needs to stay away from the Georgia State campus while she's on bond. No drugs, alcohol, weapons or guns or any unprescribed medication while on bond.
You know, if you would put it in the order, we would certainly go along with the BHET. It seems that's appropriate and
All right.
in the order.
Good. And then a BHET.
Yes, ma'am.
All right.
Was the disorderly conduct dismissed?
She did have a disorderly conduct. One of the disorderly conduct was converted into a battery.
Okay.
So you have the 2 counts of battery, Deputy?
Yes.
Okay.
Next, we could go to position number 19, Ms. Williams. Williams.
This is 24 CR 00607 Candace Williams, charged with 1 count of simple assault. Pretrial.
It's a third. 2020 out of the cab with simple battery DV first offender. It's listed as a 1.
Okay.
And that's my case, Your Honor. This is an incident that occurred in the bus at King Middle School on the 27th of August at about 4:30 while the bus was in the lane there still on campus. That's 545 Hill Street Southeast. There was a disturbance. Officers responded. They were nearby. An administrator also responded and was a witness. The defendant was observed standing in her bus with a metal bat in the air, yelling about the disrespectful children on the bus. People were trying to calm the situation. A young man who's identified as the victim, Mr. Tinch, is 14. He reported that he was not sitting down because it was hot and he was waiting for the bus to start moving so that air would circulate and then he would sit down. So an acknowledgement that he was not following directives. An administrator wrote that she heard the defendant saying, "Get off my bus, get your ass off my bus," and observed the defendant reaching for the metal bat she had next to her seat. Bus surveillance was reviewed. It shows the defendant and the young man having a pretty intense conversation. And there was audio as well. The young man explained to the bus driver that he didn't know her and she has to earn his respect. And that's when she went over and got her bat. The charge in this case, Your Honor, is a simple assault for placing this young man in a position where he felt he was going to be injured. There is a first offender sealed conviction, and so the request for the state is a $2,000 surety and no contact. We spoke to the mother of the young man. His little brother was also on the bus. She said she's aware, but she's never had any issues with this woman. And she just thinks maybe they shouldn't have any contact. So thank you.
All right. This case, PD McLean or Cook?
McLean.
McLean.
There we go. Your Honor, she has been a school bus driver. That will be over with this incident. She'll have to seek other employment. We'd ask the court to consider a signature bond based on what we've just heard. I think it'd be sufficient to have her stay away and have a signature bond and come to court on time. She is a very organized person in terms of she won't be missing court and she'll be on time. We have a good address, phone number, and contacts.
This happened, I guess, yesterday, less than 24 hours. I'm
Yes, Your Honor.
assuming there's been some cool down, I hope. Obviously, she can't drive the bus with children, or shouldn't drive a bus or be around children. I will order the $2,000 signature bond through pretrial. And with that pretrial order, I will ask her to take 1 week of anger awareness courses, stay away from King Middle School. I would say stay away from children, but I won't go that far. Definitely stay away from the school. No further contact with the victim, Mr. Tinch, who is a minor. I'm going to go one step further. No jobs in the school system until she's off bond. I don't want her to go and get another job in school.
Thank you, Your Honor.
What level?
Oh, level 1. No drugs, alcohol, weapons, or guns while on bond.
Next, we can go to position number 16, Ms. Pugh.
This is 24 CR 0006064H. Takuria Pugh, charged with 1 count of simple battery family violence. Retrial.
First.
State.
And Your Honor, that's my case. One moment, I want to make sure I give you correct information. This is an incident that occurred on the 27th of August, so yesterday. at 111 John Wesley Dobbs Avenue. That's the address of the victim in this case. The victim in this case is the father of the child that Mrs. Pugh shares with him. His name is Robert Mobley, Mobley. Police responded to the location where they spoke to the defendant. She said that the child that she shares with Mr. Mobley had been in images posted on social media by the defendant sitting on a couch as he and other people rolled blunts. She was upset with him about his behavior, and she felt he was leaving the child with people for days and not taking care of the child. She admitted to snapping, and she struck the defendant or the victim in the face, Your Honor. This is one count of simple battery family violence. I would note that a review of the Fulton County case system does not reveal any legitimation or child support or marriage or divorce documentation between these two individuals. We did speak to Mr. Mobley. He reports they're no longer in a relationship and that they share a child. He requests that she be ordered to stay away from his residence. He said that this occurred when he was taking their son to be with his mom, but she was standing outside. And then they argued and she attacked him. He had previously told her not to come to his residence. So, Your Honor, in a situation like this, we would absolutely request no contact. We think a $500 SOB through the jail is appropriate. This is this young lady's first arrest. And ultimately, if this child has not been legitimated, then he or she needs to be with mom, Mrs. Pugh. And that's it. If they're going to be exchanging the child, which Mrs. Pugh is not obligated to do, since Mr. Mobley has no legal claim on that child, they'll have to arrange that through a third party. And so we'd ask for a no contact order until further order of Superior Court on the issue of custody and legitimation. Thank you.
All right. And so the victim in this case, Robert Mobley, is the father.
Yes. And he's on the Zoom. We have spoken with him if you want to ask him a question or sound for him.
Mr. Mobley. Robert Mobley. All right, go ahead, Petey McLean.
Your Honor, we agree, $500 signature bond through the jail and no contact by my client with Mr. Mobley is entirely appropriate.
Okay. I will order that $500 signature bond through the jail. I will order no further contact with Robert Mobley. Stay away from 111 John Wesley Dobbs Avenue. No drugs, unprescribed medication, alcohol, weapons, or guns while on bond.
Next, we can go to position number 5. Mr. Cease.
This is 24 CR 006075J. Sukulafil, I guess is Cease. Pronounce your last name, sir?
Cisse, Zuckerfield Cisse.
Cisse.
Malcolm Connor here from Mr. Cisse as well.
Oh, where are you? Oh, I see you. I'm
on
sorry,
Zoom.
Attorney Connor. I saw you, but I didn't see you. All right.
No problem.
All right, we have private counsel. We've had 2 charges. 1 count of reckless driving, 2nd count of distracted driving with the wireless device. Pre-trial.
I got first. Wanted out of the DeKalb County though.
Oh.
Jail was direct.
Okay. State.
Yes, Your Honor. This incident occurred August 13th, 2024. Officers were investigating a YouTube video belonging to the defendant, which was titled "Cutting Up in Traffic in My Hellcat." In the video, the defendant is seen driving between 121 miles per hour to 155 miles per hour on Interstate 7585 southbound at around 2:49 a.m. In the video, the defendant is also seen holding an electronic device in his right hand. Given that this is the defendant's first arrest, the state would recommend a signature bond. It may be appropriate to not allow him to drive while he is on bond, given the reckless nature of this incident. Someone could have been seriously harmed by the defendant's behavior. We would also request no drugs, weapons, or alcohol while out on bond.
All right. Mr. Connor, do you have any objection to a signature bond?
I have no objection to the signature bond, but I do have an objection to the condition that he should not be able to drive. Mr. Cisse is 19 years old. He's a high school graduate. He's a resident of Riverdale, Georgia. He has resided here for his entire life. He has strong ties to the community. My client is a social media influencer, YouTuber. I believe the video that she is referring to does not show my client's face in that video. So I would say the proofs are not certain and the evidence is weak. And for that, Your Honor, I would ask for the condition to not be set in place.
He's 19 and he was driving a Hellcat.
He owns multiple cars, yes, Your Honor. Like I said, he's a self-made entrepreneur, YouTuber, social media influencer.
Right, but he's going 121 or anything over 75, 80, 85. I know these are just allegations, but my concerns are there, especially with the type of vehicle.
No,
And
we understand, Your Honor. He was not in, his actual face was not in that video. From my understanding, it was somebody else driving the car at that time.
oh, someone else is
It's
driving.
his YouTube channel.
But the car is registered to my client. There's no videos, from my understanding, there's no videos on YouTube that show my client actually driving these cars at this rate of speed.
So the video was uploaded to his YouTube channel titled "Cutting Up in My Hellcat," referring to the vehicle that belongs to him. So our argument would be that
what's his face in the video? That's what I'm saying.
Your
We're not
Honor,
going to argue
we'd
the
love
fact.
to talk about this in front of a jury trial. We're here to discuss bond.
Right.
Thank you very much.
We understand. I understand
Great
that.
advocate.
I'm just letting Your Honor know that the evidence is not strong. It was not
Well,
my client in that video.
I understand that's a different argument and a different motion. At the moment, I am making sure at 19, he's barely over 18, obviously, that he will be returning to court. He just turned 19 in May.
Yes, Your Honor. And he will have counsel throughout the duration of this case. So I will make sure he will be present at every court proceeding.
Okay. I'm going to give him a higher signature bond just to make sure that he understands the severity of what he's doing, whether he's videoing it himself or driving or not driving or participating in it. They could have killed someone, could have killed a lot of people, more than one person. And I don't, I hear a lot. We're filming, we're videotaping, we're recording. Still, it's very, very reckless conduct, especially around Atlanta with the traffic and the number of people that we have. So I'm going to give him a $5,000 signature bond. And that's going to be $3,000 on the reckless and $2,000 on the distracted driving. There is a course that I want him to take while he's on bond. It's called Alive at 25. And we hope he makes it to 25 with this type of conduct. So he needs to have that certificate prepared and ready and take that Alive at 25 course online and pay the cost for that. Does he work?
Like I said, Your Honor, he's an entrepreneur, so he gets paid off of YouTube.
I'm inclined to say that he shouldn't drive, but I'm gonna tell you what, he better drive at the speed limits and nothing over 85 or 80. There shouldn't be any reason for him to be driving like that. If he comes back again, you know, maybe we won't give him a bond. But he needs to drive safely. And if he's filming, he need not be going above the requisite speed limit for wherever he's driving or riding. So if he's filming someone else, you tell that person, we can't go 100 because I'm on bond and I'm gonna get in trouble and have my driving privileges revoked. I was going to say he would go to work, but I guess that's his work. Usually we limit the person's driving. And you know, no drugs, alcohol, weapons, or guns while on bond. I think that's all out order at this
Was
time.
that the pre-trial
Oh, I'm sorry. His signature bond is through the jail.
to the jail? Okay, thank you.
Mhm. Okay. Hopefully he learns a little bit in the Alive at 25 class.
Thank you, Your Honor.
All right. Thank you.
That concludes my business for today. May I be excused?
Yes, you may. Thank you.
Thank you.
Mhm.
Next, we can go to position number 7, Mr. Crosby.
24 CR 006077F. Harold Crosby charged with 2 counts of simple battery family violence. Pretrial.
15. Last arrest was in May for simple battery DV. 24 CR 003341E. 08 larceny conviction. 07 eluding conviction.
All right. State.
Yes, Your Honor. This incident occurred May 7th, 2024. The victim in this case is 17-year-old Olivia Grace Lewis, who is the defendant's stepdaughter. The defendant is accused of pushing the victim and grabbing her by the throat, effectively choking her because he did not like her response to his request that she contribute to household chores. The defendant admitted to pushing the victim and also admitted to picking her up by the throat. Our office has had a chance to speak with Ms. Lewis, who stated that they have moved from that incident location and they now live at 1475 Boomer Circle, Atlanta. She confirmed the events in the warrant and stated the defendant also pushed her to the ground, got on top of her, and began to choke her. She stated she was unable to breathe and did feel like she was going to lose consciousness. She stated this is not the first time the defendant has been violent towards her, but this is the first time the police have been involved. She did state that she is planning to leave for boot camp in a few days. Given the defendant's criminal history, which does include violent arrests and felony convictions in multiple states, he has 1 arrest out of California, 4 arrest cycles in Virginia, 6 arrest cycles in Ohio, and the fact that we are worried that he will intimidate this victim, as this is not the first time that he has been violent towards her, and as well as the disturbing facts of this incident and the fact that he had a violent arrest earlier this year. The state's recommendation on the first count of simple battery is $1,000. The state's recommendation on the second count of simple battery is a $3,000 surety, no further contact with this victim. Stay away from the incident location as long as the victim is living there. The victim did state that she's planning on leaving for boot camp in a few days, but as long as that victim is living in that household, we will ask that the defendant stay away. We are also requesting anger awareness as well as no drugs, weapons, or alcohol. And the simple battery case is against his wife, Ms. Dina Crosby, and he was ordered to have no contact with her. So I'm assuming Ms. Dina Crosby lives at the residence, and so if he's ordered to have no contact with her, then he's ordered to stay away from that residence altogether. We are asking for no drugs, weapons, or alcohol, and if I didn't mention earlier, we're also asking for anger awareness. I would ask the court to sound for Miss Olivia Grace Lewis.
All right, Miss Lewis. I think I see Miss Crosby on, but the victim in this case is Miss Lewis. Is that correct?
Yes, that is correct, Your Honor.
And I do see as private counsel Attorney Johnson.
That is correct, Your Honor.
Okay, we'll be with you in a second. And this case is not involving Dina Crosby, although I do understand that Miss Lewis is 17 and she's a minor. Is she on the call or not? Miss Crosby, is your daughter on the call?
No.
Okay.
Yes, but we did speak with her. Our victim advocate spoke with her earlier today.
Okay, great. And she doesn't want to have any further contact, correct?
Yeah, she says she doesn't want to have any further contact, and this is not the first time that he has been violent towards her.
So I'm assuming Ms. Crosby and Ms. Lewis do not reside in the home with the defendant any longer.
So based on what our victim advocate, the conversation our victim advocate had with Ms. Lewis, they do reside at the incident location, not the incident location. They moved to a new location, 1475 Boomer Circle, Atlanta, and that is where they live. The victim stated that she's going to be leaving in a few days, but it's my understanding that she's still at the residence with the defendant.
Okay. Conflicting, but I guess I get it. Maybe she's temporarily somewhere. All right. Mr. Johnson, have you pulled
Yeah.
over, Mr. Johnson? Let me ask you that
Yeah.
first. Have you pulled
Yes,
over?
Your Honor. I'm in the parking lot. Yes, ma'am.
Okay, great. Thank you. Go ahead.
Yes, ma'am, Your Honor. Before you is Mr. Harold Crosby, a 39-year-old Atlanta resident. He is employed at an aircraft company, Your Honor, has been employed there for the past 3 years. Your Honor, we have no problem with no contact whatsoever with the alleged victim in this case. It is our understanding that she will be leaving for boot camp soon, so we do not have a problem adhering to that, Your Honor. We would have an issue with regards to the anger management cast. While there is allegations that this has happened before, none of those have been reported to police officers or resulted in any kind of prosecutions. So at this point in time, Your Honor, there is no basis for that. He does have some prior matters. I believe his last felony conviction was, as stated, was in 2008, 16 years ago. Your Honor, he does have a prior misdemeanor charge against the mother. If I could get that case number, I believe it was 24 CR 0031 something. But in that particular matter, Ms. Crosby is online, Your Honor. She is seeking to have the no contact provision stricken from that. So we will be attempting to do that. I know that this is not the forum to do that at the present time. So, Your Honor, we would ask for a reasonable bond not to exceed $3,000 in this case. And if necessary, we would submit to pretrial supervision level 1 in this matter. And if the court will be so inclined, we do believe that he could be a good candidate for a signature bond in this matter as well, Your Honor. But if the court would not be inclined to give him a signature bond, we would ask for a bond not to exceed $3,000 total on these charges without the requirement of him to attend an anger management class and include any kind of no contact provisions and stay away provisions that the court would be so inclined. Thank you.
Okay.
In Your Honor, we do feel that anger awareness is appropriate since this is his second arrest this year alone for a violent attack on a family member.
Right. Okay.
And I would just respond to that, Your Honor. If the state feels that way, that could be possibly made a portion of any sentence. If he was so found to plead guilty or found guilty of these charges, I understand that will probably be a part of his sentence. However, we do not believe, given that he does enjoy the presumption of innocence at this time, that it will be appropriate as a condition of his bond. Thank you.
Okay. All right, I'm going to order $4,000 signature bond through pretrial, which will be $2,000 on each of the charges. I am going to put him at level 1. I'm sorry, level 2. I'm gonna put him at level 2. And with level 2, I'm going to order a 1-week anger awareness course, which is free through pretrial. And I disagree, counsel, and I understand you're representing your client, but there's something going on in that household with 2 women there having cases of violence. No further contact with the victim, Miss Lewis. Stay away from Miss Lewis. It's confusing about her residence, and maybe she'll be gone, but no further contact is what I'll do. I guess at this moment I won't do the stay away since that seems to be his address.
So it looks like They used to reside at 1410 Old Riverdale Road in Roswell. That's where they resided when the incident took place. Since then, they have moved to 1475 Boomer Circle in Atlanta, and the victim, Ms. Lewis, is currently living there, it is my understanding, until she leaves for boot camp. So until she leaves and it's confirmed that she doesn't live there anymore, we would just ask that he stay away from the residence they are currently living in.
All right. And I don't know if you're aware of this, Mr. Johnson. Does your client have somewhere to stay for a few weeks until the victim leaves for boot camp?
Yes, Your Honor. My client would be able to find alternate residence if necessary.
Okay. So let me order this until we know that Ms. Lewis is safe and has gone to boot camp and left the home, wherever that home may be. He's to stay away from the new residence. I won't order him to stay away from the old one if they don't live there anymore. What was the street name of the new residence?
Boomer Circle.
Boomer Circle. I need him to stay away from there for a couple of weeks, it seems, until Miss Lewis is gone. What I usually order is that they take an officer with them, law enforcement, to go and make sure that the victim is no longer residing there or has left for boot camp and won't be there for a minute, and make sure that that is the case before he can stay there. And that's what I'll do, just to make sure in case she changes her mind, doesn't go to boot camp. So in the order, Ms. Bridgewater, if Miss Lewis, the victim, is residing at that Boomer Circle or any home residence, Mr. Crosby cannot reside there, even though he may be married to Miss Crosby. He cannot while on bond, and no further contact with her, and no drugs, alcohol, unprescribed medication, guns or weapons while on bond. Did I leave anything else out, counsel?
Hey, this would be per,
No, Your Honor.
Yeah, level 2.
hey, this would be per judge because he got the
Per
open
judge.
case already. So
Okay. Right. All right. I think that'll be it. Anything else, Mr. Johnson?
Yes, if I could please get the case number for the other matter that is currently
No.
pending.
Pre-trial, can you give him
The
that case
cover,
number?
I
Or
can
who
give it
has
to
it?
the judge. That case
Okay.
number is 24 CR 003341 E as in Edward.
You said 3341 E as in Edward.
Yeah, 003341 E as in Edward.
Okay, yes, ma'am, I have it. Thank you very much.
You're welcome.
All right. Thank you.
All right. Thank you, Your Honor. May I be excused? That concludes
Yeah.
my business.
Yes, you may. Thank you.
Thank you.
Uh-huh.
Next, we can go to position number 1, Mr. Adams Ingram.
This is 24 CR 006067G. DeMarcus Adams England, charged with 1 count of simple battery family violence.
third arrest, 2023 FTA, 2023 suspended license, suspended registration, making false statement pertaining to vehicle insurance. This is 1.
All right. Okay.
Yes, Your Honor. This incident occurred on August 24th, 2024. The victim in this case is Ariana Smith. She is also the co-defendant, as she was also arrested. And that case number for her is 24 CR 006013G. She lives with the defendant at the incident location, and they also share a child. The parties were having a verbal dispute about the victim leaving the oven on, and the victim threw a water bottle at the defendant, and then he charged at her, pushed her into the door, then pushed her onto the couch. Officers did not observe any visible injuries on the victim. As I stated, both parties were arrested. The state's recommendation is a signature bond through pretrial services, no further contact with the victim, no drugs, weapons, or alcohol while out on bond, and this is consistent with the bond that Ms. Ariana Smith was also given. We would also recommend for this defendant some anger awareness. And I would ask the court to sound for Ms. Ariana Smith if she happens to be on the Zoom.
So Miss Smith is not on my calendar today.
No, she's already been on the calendar. She got an SOB jail and no further violent contact with the defendant.
Okay. And there, do you know, it says I think you stated they do live together or they don't?
They do live together.
Okay. All right. Oh, is this Miss McLeod?
Yes, Your Honor, good afternoon.
Good afternoon.
Your Honor, I'd be asking for a signature bond for the jail for my client. He has no criminal history at all. So his previous arrest was traffic related. He is a teacher. He tells me, and that is how he is employed. So he's not someone who is running around committing crimes. Since the cross defendant was given a signature bond to the jail, I see no reason why my client should not have the same, Your Honor. And since the court is saying no further violent contact, that is also what we would prefer because they do share an 8-month-old child. Nothing further, Your Honor.
So I thought that the state said it was no further contact, not no further violence. Which is it?
It's no further violent contact, Your Honor. I apologize.
I'm Miss Smith. Oh, okay. Okay. I may have heard that incorrect. All right. I will order a $3,000 signature bond through the jail. And I'm going to order no further violent contact with the dual or cross defendant.
Yes, Your Honor.
Ms. Smith. And I'm going to order no drugs, alcohol, weapons, or guns while on bond. I guess that'll be it. Anything else I missed, counsel?
Nothing from the defense, Your Honor.
We had asked for some anger awareness, but we leave that to the court's discretion.
My client is 33 years old, Your Honor. He has no history of any kind of anger or violence or anything. And his job is a fairly challenging one. Not only is it a teacher, he's a teacher of special needs children.
Right. Well, he needs to obviously de-stress a little some other way, possibly. But I won't order any anger awareness at this point. All right.
Thank you, Your Honor.
Thank you, Your Honor.
I'm sorry, Your Honor. Can I interject? I just have a question. I know you've moved past my husband's case, but
I cannot go back. I cannot go back, Ms. Crosby, because the matter before the court today was involving your 17-year-old daughter. She would be the only one that I would allow to speak about the case. She's the victim. I'm not going to litigate or talk about the previous case or the one.
No, I wasn't going to do that. I was just stating that he was never arrested for the incident with my daughter, only with myself, and I don't understand. Okay.
What do you mean he wasn't arrested for the incident? That's what he's in for today, the incident with your daughter. But what do you mean?
When the incident, the night that he was arrested was because I called the police on that, but there was no arrest for that.
State, I'm not for sure if she understands what she's saying.
Maybe
he's arrested. Go ahead.
Maybe because he did have a warrant out for the incident that happened with the daughter. So maybe when he was arrested on the incident that happened with Miss Crosby, that is when they also arrested him for the incident with the daughter.
Okay.
Because the incident with Miss Crosby is more recent.
That's fine. We're done with that case, Miss Crosby.
Sorry, I didn't mean to interrupt. No offense to you, Judge. I apologize.
I'm sorry,
Okay,
Judge,
thank
but
you.
that's incorrect. He was just arrested on this warrant. The incident happened on May the 7th, 2024. Why he got picked up, I don't know. He was just arrested August 28th for an incident that happened on May the 7th of 2024.
Which would have been Miss Crosby's case?
No, that is
no, it's this case, the case with dealing with the daughter.
Okay. Okay. All right. Maybe you should speak to his attorney about that, Miss Crosby.
Okay. Okay. Thank you very much.
Uh-huh. All right.
Your Honor,
Go ahead, Miss McLeod.
That concludes my business before the court today. May I be excused?
Yes, you may. Thank you.
Thank you, Your Honor. You're welcome.
All right.
Next, we go to position number 10, Mr. Hill.
This is 24 CR 006080D, Aaron Hill, charge of 1 count of battery family violence. Pre-trial?
7 total. 2022 DUI, 2019 inflict corporal injury. This is out of California. 2018 reckless driving assault conviction.
All right, state.
Yes, Your Honor. This incident occurred August 27, 2024. The victim in this case is India Spears, who lives with the defendant and is also his girlfriend. The parties were having a verbal dispute that turned physical when the defendant grabbed the victim in the face and in an aggressive raking motion that left injuries to her lips, face, and neck. We have had an opportunity to speak with Ms. Spears, who confirmed that they are in a relationship, they do live together, but they share no children. She confirmed the events in the warrant, but stated that she does not know how she got the injuries to her neck and her face. She states they were both intoxicated at the time of the incident. This has never happened before, and that she is not in fear of the defendant and wants to continue contact. She did state that she is planning to leave the residence and does not want to press charges. Given the defendant's criminal history, which does include violent arrests and convictions, as well as arrest cycles in multiple states, 2 arrest cycles in California and 3 in Texas, the state's recommendation is a $2,500 surety bond. No further violent contact with the victim based on our office's communication with her, anger awareness, no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for Ms. India Spears.
All right, India Spears. India Spears.
Yes, Your Honor.
All right, do you wish to address the court today? Yes or no?
Yes.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. Are you in fear of Mr. Aaron Hill?
No.
Do you want to have any further contact with Mr. Hill?
Yes.
And you all share a child?
No.
No children. I'm sorry, no children. But you were living together?
Yes.
Okay. And that's all that I have. Any cross-examination questions by the state or PDs?
None from the state, Your Honor.
Nothing, Your Honor. Thank you.
All right. Go ahead, Mr. McLean.
We would ask the court to consider a signature bond instead of surety bond. Apparently, they're not going to be together, and we would agree that no further violent contact would be appropriate, but I think that she's not going to stay there, if that heard correctly, so we would ask the court to consider, despite that record, the signature bond. He has an administrative job with a corporation. He's been there for a couple of years. He does administrative matters and sales. So with organizational skills like that, he won't have any trouble making court on time.
All right. I'm going to order a $2,500 surety bond. And with that surety bond, no further violent contact with India Spears. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And I guess that's it. Anything else, counsel?
No, we had asked for anger awareness, but of course, leave that to the discretion of the court. And that was given his 2018 assault conviction and 2019 arrest for inflicting corporal injury on a spouse/cohabitant.
Been some years. I'll give him a pass and hope that he's done doing such things going forward.
Thank you, Your Honor.
Thank you. Attorney Connor, I see you're back.
Yes, Your Honor. I'm back for Bernard Moore III.
No. Next, we could go to position number 4, Mr. Chisholm.
Bernard Moore is position number 14.
I understand.
Are we doing 14 before the attorney's case? Because I didn't realize he had two.
I didn't either.
I just got hired on this case, Your Honor.
Okay, I got it. Let's do this one and then we'll do yours.
All right, no problem.
All right, so we're on 14, no.
4.
Well,
Position 4.
All right, this is 24 CR 00607 OF. Kevin Chisholm, charged with 2 counts of battery, family violence, and 1 count of cruelty to animals. Pre-trial.
8th arrest, 2013 FTA,
Get out.
2013 drug possession, 2013 armed robbery conviction, 09 burglary first offender.
All right. State.
Yes, Your Honor. This incident occurred August 26th, 2024 at 2748 Colonial Drive, College Park. The victim in this case is Kiara Fleming, who lived at the same residence as the defendant. Ms. Fleming states that her boyfriend, the defendant, asked to see her phone, and when she refused, he became aggressive, grabbed her arms, threw her on the bed, got on top of her, and threatened to strike her. She did leave the room, but was convinced to come back by the defendant so that they could talk. During their discussion, the defendant became angry and aggressive again. He punched the victim in the face, pushed her, scratched her, threatened her with a gun, told her not to call the police. And the defendant's mother, Ms. Denise King, told officers that the defendant had asked the victim to leave, and she became agitated and started kicking things in frustration, and she slipped and fell, and that is what caused her injuries. Officers did observe that the victim's foot was bleeding, and she also had scratches on her upper back. Officers also saw a video from earlier that day in which the defendant is seen throwing a dog onto a white object, causing the dog to flip over the object. Our office has had an opportunity to speak with Ms. Kiara Fleming, who states that her and the defendant are no longer in a relationship. They no longer live together and they share no children. She confirmed the events in the warrant and stated the defendant threatened to get his gun and stated, "I'm going to kill you. I'm going to bury you in the backyard." She was on the phone with her mother and sister during the altercation, and they had to call the police for her due to the defendant preventing her from doing so. She stated the defendant was throwing her belongings outside and the dog got out of the house. The defendant was calling the dog, but the dog wasn't listening, and so he picked up the dog and threw the dog into her stuff that he had thrown outside. The victim states this has never happened before. This is the first time the defendant has been violent towards her, but she did state she wants no contact. The defendant's mother told her that she had to leave the residence, and the defendant's mother has been preventing her from getting the rest of her belongings, so she would like a one-time law enforcement escort so that she could retrieve her things. The state's recommendation is a $1,500 surety bond on each count of battery, a $500 surety bond on the cruelty to animals, and that is based on the defendant's prior criminal record, which does include felony convictions. There is also a risk that he will intimidate the witness, given that the defendant has already threatened the victim. We would ask for no further contact with the victim, anger awareness, no drugs, weapons, or alcohol, and for the victim to get a police escort so that she could get her belongings, and for the defendant and his mother to allow her to do so. I would ask the court to sound for the victim, Ms. Kiara Fleming.
What's the mother's name? Do we know?
Denise King.
I'm present, Your Honor.
You're Miss King on your Galaxy S9?
Yes, ma'am.
Okay, you're not the victim in this case, but of course they've mentioned some actions by you, and I can handle that without speaking to you today. This is a bond hearing. Is Miss Fleming on the call? On the Zoom, Miss Fleming? All right, please mute yourself, Miss King. I'm not going to speak with you today because this is not the proper forum for that, okay? Thank you for getting on. All right, go ahead, Mr. McLean.
Your Honor, they won't be together. It is apparently Mrs. King's place. I think suitable arrangements for residents will be had. So the visit to get her to retrieve her belongings is entirely appropriate. I would ask the court, since this is alleged to be the first violent incident, we would ask the court to consider a signature bond.
How old is Mr. Chisholm?
Let's see. We're looking for a date of birth here.
91.
33 years old.
And tell me again, what did you say about employment?
I didn't.
Okay. Does he work or not?
Mr. Chisholm, can you address the court as to your work, please?
Yes, sir. Bobo's, it's a warehouse.
You work in a warehouse?
Yes, ma'am.
How long you been doing that?
About a year, since I've been out, a year and some change.
And so, and the residence here, the Colonial Drive in College Park, is your mother's home?
Yes, ma'am, that is correct.
Okay.
Yeah.
And Miss Fleming was living there?
Yes, ma'am, I did allow her to live with us at the time. This is a major inconvenience for me, given the fact that my mom is disabled. Allegation.
Mr. Chisholm, you answered the question. Thank you.
Okay, yes, sir.
All right. Let's see. Let me order. I'm a little disturbed about this cruelty to animals allegation. Sounds a little disturbing. I guess I will order a pre-trial. You take them or not?
Who's this again?
Number 4, Chisholm.
Said level 3 on the PSA.
Yeah, we ain't worry about that right now. Yeah, that's fine.
You'll take them. All right, I'm going to
But
order.
not level 1, not level 1. Whatever
No,
level but 1.
Yeah, I was going to do him level 3.
Okay.
As well. So I will give him a signature bond through pretrial. I'm going to give it for $2,000 on each of the batteries. And $1,000 on the animal cruelty. So that'll be $5,000. Hold on one sec. All right, sorry about that. It will be a total of a $5,000 signature bond through pretrial. Level 3.
Rejected on.
I'm going to order 1 week of anger awareness. Do you all have a dog class over there at pretrial? Animal cruelty class?
I don't know about that one. I'll call real quick and ask though.
Okay. Now, if you do, I'd like to order him to take one.
There's
There are
the
your
BARC class, right, Mr. McLean?
right. The BARC, I think there's a dot, a period after each initial. BARC is an online course that consists of I think it's over a dozen hours, costs about $200. And it's specifically for cruelty as opposed to neglect.
Have we used that, ASG Allen? Okay,
We have.
let me order him to take the BARC
BARC, okay.
and put on their BARC animal cruelty class. He's to take that online.
Okay.
And I'm going to order him to have no further contact with Miss Fleming. He's to stay 200 yards away from her. Also, I believe that is it.
So
Drugs, alcohol, weapons, or guns while on bond. Yes, sir.
you want me to see if they do it for free downstairs or what?
Yes, let me.
Just so they'll know. All right.
Yes,
So
sir.
Holly, kind of hold off on that one, on that.
Right, we'll see
order. All right.
which one. Okay.
What level was that?
Level 3,
What was the breakdown, Judge?
2,000 on each of the batteries, 1,000 on the cruelty to animals. There's a total of 5,000 SOB pretrial. And I want to add to this order, Ms. Bridgewater, that Miss Denise King is not to prevent the victim from getting her items from the home, or else we'll pick her up.
Got it.
This victim should be able to get a one-time law enforcement escort to come back to the property to be able to get her personal belongings and be free of any interference or hindrance by the defendant or the defendant's mother.
Okay.
She's on the line, Judge. She just don't want to speak.
No, I told her she didn't need to speak.
Yeah, okay.
She clicked on to speak, I believe. And I told
Yes,
her I didn't
ma'am.
need to hear from her today. But
Yes,
I do
ma'am.
want to make sure that she allows Miss Fleming to come there without any hindrance to get her personal items. Miss Fleming is going to bring a law enforcement escort, so they'll know how to handle Miss King if there's any interference.
And I will put that in the order.
One
Thank
question, Judge.
Yes.
question.
Be careful on your question.
I know, ma'am. I know. I understand.
Mr.
Thank
Chisholm,
you, sir.
Mr.
Thank you, sir.
Chisholm. Mr. Chisholm.
Thank you, sir. Thank you for my representation. He said I can ask you a question, Judge. I can ask you. You know what? You're right. All right. Thank you, ma'am.
Yeah.
Position number 14, Mr. Moore.
Okay. All right, this is 24 CR 006063A. Bernard Moore, charged with 1 count of simple battery, represented by attorney Malcolm Connor. Pre-trial? Oh, he might have stepped away, or did you?
I'm back. Yeah, I
Okay.
just sent the email out. Second arrest.
Okay.
Last arrest was
Yesterday.
Yesterday?
Yeah.
Possession of marijuana. This was outstanding, so that's what happened.
Yeah,
Oh,
Your Honor,
okay.
the incident in
Yeah.
front of you is from June, so there was an outstanding warrant. The date is June the 3rd of 2024. The victim in this case, her name's Ashley Dickerson. This incident happened in a parking lot at 230 Cleveland Avenue. Victim on scene reported that they were in the parking lot in the car arguing, and the defendant began repeatedly striking her in the face. There was a witness on scene who spoke to police and said that the defendant was in the car hitting Ms. Dickerson like she was a man before throwing her out of the vehicle. We have not been in touch with Ms. Dickerson yet today. I did just pull up the report, which I didn't have previously. It says that they share 2 children, and it also says that there were visible injuries. So this will actually be reaccused or have other charges put on it. But we'll reach out to Ms. Dickerson and get more information, obviously. This young man doesn't have much criminal history. I understand that his mother had been in touch with defense counsel, and I think there's a discrepancy about what kind of relationship these folks have. So until further information from the victim, I'm not going to change anything. I think the allegation is that they don't share children, even though that's what it says in the report. We're asking for a $2,000 SOB bond through pretrial level 1, no contact with Ms. Dickerson, and stay away from wherever she lives.
Okay.
Thank you.
All right, I'll start out a little bit, Mr. Connor. I am inclined to grant the $2,000 signature bond through pretrial level 1. So you can tell me about any objections to the other conditions.
No objection, Your Honor. Like the state said, that from my understanding, the two do not share any children. So if it's accused under family violence, I would just say that would be inaccurate. It should be accused just simple battery. He is 27 years old. He's currently in school, in mortuary school. He's a high school graduate. He comes from a very supportive background. He recently lost his father and his mother, a very supportive mother. He will be on time and will show up to every court proceeding, and he will have counsel for the duration of this case. I have no objection to the state's bond through pretrial services.
Okay. All right, I will order the $2,000 signature bond through pretrial level 1. And I'm going to order, since he's at pretrial, for the 1-week anger awareness course, which is free through pretrial. I'm going to ask that he have no further contact with Ashley Dickerson, and that she stay away from her residence and or her job, wherever she may be. He's got to stay 200 yards away from her. And no drugs, unprescribed medication, alcohol, weapons, or guns while on bond. And I think that'll be it. Did I leave out anything, counsel?
Nothing else from the state, Your Honor. Thank you.
All right, thank you.
Hey,
Yes.
yeah, he would have to pay for that class out of pocket. They don't offer that.
Okay. All right, so the BART class, excuse us, Mr. Connor, the BART class, he'll have to pay out of pocket, but I am ordering him to take that on the other case. And then I think there's nothing else on Mr. Moore's case. Is that correct? Just the 1-week anger awareness through pretrial.
Understood, Your Honor.
Okay.
Next, we will go to position number 12, Mr.
Thank you.
Okay, thank you, Mr.
All right.
Connor. We'll either see you back or we won't.
All right, see you.
Okay, thank you. Bye-bye. All right, I'm sorry, Deputy. Who did you say?
Position number 12, Mr. Hurston.
12, okay. This is 24 CR 006082C. Chavarez Hurston, charged with 2 counts of battery family violence. Retrial.
10th arrest. 2021 suspended license, couple of probations from 2019 and 14. I didn't see any violence during that time period.
Okay.
If he does have violence, I didn't see any convictions anyway.
That's my case, Your Honor. There was a null pros battery family violence in Clayton County and ag assault in Clayton County. That was no build. The only convictions I see are 2 DUI convictions. This is an incident from the 27th of August at 1 p.m. The location is 6115 Hillendale Drive in South Fulton. On the way to the location, so the victim called 911. Her name is Latoya Bowie, B-O-W-I-E. She called 911 and reported that there'd been a physical dispute where she'd been assaulted by the defendant and he'd fled. She gave a description of his vehicle. While police were en route, they saw the defendant in his vehicle and initiated a traffic stop and directed him back to the location. The victim reported that they had had an argument that escalated, and he began punching her at least 5 times in her face. She was seen to have swelling on her face on the left side, a laceration, and she was bleeding. The defendant admitted that there had been an argument, but denied that there was any physical contact other than the fact that he said she tried to prevent him from leaving. We have been in touch with the victim, Ms. Bowie, B-O-W-I-E. She said that this is not the first time there's been violence, but it's the first time that she's called the police, and the landlord at that location is requesting the defendant not return. She also says she is not interested in having any contact and that they do share a child. We're asking for a $4,000 surety, Your Honor, no contact, stay away from the location, and no drugs, alcohol, or weapons while on bond. And I'm not sure if Ms. Bowie is on the Zoom. I see her, if she would like to address the court, if you might sound for her.
All right, Ms. Bowie.
Yes, I'm here.
All right, do you wish to address the court today? Yes or no?
Yes.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down. Are you in fear of Mr. Hurston?
Yes.
Do you want to have any contact with Mr. Hurston?
Only for the sake of his daughter. If we can get a third party in place for exchange with the child, that's fine. But other than that, no contact.
All right.
Ms.
Has he
Bowie?
legitimated the child?
No.
Does he have a visitation order agreement?
No.
And you don't have any fears of him visiting with the child?
No.
Okay. All right. We can move on. Who's representing Mr. Hurston? Oh, go ahead, Mr. McLean.
Your Honor, he works at a warehouse for one of the two large competitors for home improvement in the nation. He is not going to be in contact with her. He has already arranged for an alternate address in the metro area for him to go to work and just stay away from her. And the third party transfer sounds fine, Your Honor. We would ask the court to consider a signature bond in that, although there was one that was apparently in diversion or dismissed for whatever reason, or maybe a better reason than that, there were no violent convictions and no felony convictions and no FTAs. That's all from the PSA that I was looking at.
All right, I am going to order that $4,000 signature bond through pretrial. $2,000 on each of the battery cases or charges rather. I'm going to order him to take 1 week of anger awareness through pretrial. I guess he'll be a level 1. On this Hillendale Drive, whose address is that?
That's where he's going to stay away from, I believe. Is that correct?
Okay. Staying away from that address, is that correct, State?
Yes, Your Honor, I believe so, if that's not his address.
Right. All right, so stay away from the 6115 Hillendale Drive. No further contact with LaToya Bowie. Stay 200 yards away from her. I'm in between and conflicted about this visitation. Ms. Bowie, you need to think about it. But if visitation is allowed, and I'm not requiring you to allow it, but if you do, yes, it must be precipitated by the party because he cannot be within 200 yards of you.
Okay.
So since he doesn't have a visitation order, he's not legitimated the child, you don't have to allow visitation. I'll give you that advice for free.
Okay.
Also, no drugs, alcohol, weapons, or guns while on bond. And that Hillendale Drive is your address, Ms. Bowie?
Yes.
Okay, so he's ordered to stay away from that address as well as any address where you might be or where you work, okay?
Okay.
All right, thank you.
Thank you.
Next, we go to position number 9, Mr. Hendricks.
Okay.
Yep.
This is 24 CR 00607-9G. Joshua Hendricks charged with 1 count possession of a pistol or revolver by a person under the age of 18. Pre-trial?
First arrest, he's 17.
17, okay.
Correct.
States?
Yes, Your Honor. This incident occurred August 27th, 2024. The incident location is 6020 Hillendale Drive, Atlanta. The defendant just turned 17 this past July, and he's accused of being in possession of a Glock 9. The defendant stated that he purchased the firearm about 2 days before the incident for $500. The defendant was with another individual, Kamor Quitler, and around 2:30 a.m., shots were discharged from that incident location. Mr. Quitler did admit to being the one who fired the shots from his own firearm, which had been reported stolen. Therefore, the defendant was charged with only possession of a firearm. The state's recommendation, even though the defendant doesn't have a criminal history, is based on the fact that he just turned 17 and he was in possession of a firearm underage and was roaming the streets at 2 a.m. with that firearm on his person. So there is a concern for the community at large. The state's recommendation is going to be a $5,000 surety bond, stay away from the incident location, no further contact with Kamar Quitler, as I don't think this person is a good influence on the defendant. We are also going to ask for a curfew and no drugs, weapons, or alcohol while out on bond.
All right. PD McLean?
That's
Or
my case.
PD Cook, okay?
Yes, we have no objection to the conditions of the bond, Your Honor. We would simply be asking for given his lack of a record, we understand he's young, we would be seeking a signature bond at level 3.
Who's gonna sign for his bond?
His mother, well, at this point, I have not been able to get in touch with her, but there's just Shaniqua Easley. I have her name and her phone number. He said she would. I have not been able to reach her throughout the afternoon, however.
Okay. Does your client live at home with his mother
Yes, he does.
in high school?
He is being homeschooled. He's at the senior level.
Scheduled to graduate? Is he on track to graduate?
I'm not sure about that, Your Honor. I'm not sure how the homeschooling works, but he is a senior, so he would be close at 17, I guess.
All right, I'm going to order that $5,000 signature bond through the jail with the cosigner.
Jail don't need a cosigner.
I mean, pretrial with the cosigner, sorry. SOB pretrial with the cosigner of his mother or whomever.
What's the mother
We have
name?
her name?
Her name is Shaniqua. That's Shaniqua. Her last name is Easley, Easley. It's his mother. If you'd like a phone number, I can give you that as well.
No.
Okay.
Mr. Cook, when you get a chance, will you put that in the chat so I can get the spelling correct?
Yes, ma'am.
SHANIQUA, correct?
That's it.
And what's the last name?
Easley, Easley.
Got it. Thank you.
Thank you.
This level 1, Judge?
Yes, level 1.
Your Honor,
I'm sorry?
he stated that that is not how you spell his mother's name.
Okay.
Okay.
Cook, you just made that up?
No.
That's
No,
why
it was
I actually put it in the chat.
no. It was that's how it is spelled on the booking report as his
All
contact.
right. Can he spell his mother's name properly?
SHINIKA.
SHINIKA.
Shanika. Okay. Same last name though? That's correct?
Yeah, EASLEY.
Okay.
Yeah.
Okay.
All right, Mr. Hendricks. Certainly not impressed with the allegations of the conduct. So you're going to be on a curfew. Since you're homeschooled, you don't need to go out and go to school every day, so you can stay at home a little longer. So your curfew will start at 10 p.m.
10 p.m.
10 p.m. to 8 a.m. So you need to be at home every day from 10 p.m. to 8 a.m. You should be on track to graduate or get your GED. So finish your homeschool, or if not, you need to enroll in a GED course. No guns, no weapons, no alcohol, no unprescribed medication or drugs while on bond. If you have any other weapons, you need to turn them in immediately to the sheriff's department. So hope you don't have any other weapons.
I don't got no other weapon. No, it's just only a one weapon.
No, bad choice. So we're gonna say no further contact. Can you spell Kamori's name?
Oh, not really, man.
Okay, do you have the spelling, State?
Yes, I have it as Camor. The last name is Quitler, Quitler.
Okay, no further contact with him or any other bad influences that you may tend to hang around, so that you don't end up back here at the Fulton County Jail. Stay away from 602 Old Hillendale Avenue. Whose home is that? Or what location is that?
I have it, when I look it up, it is a residence. I'm just not sure whose residence it is.
Okay, Mr. Hendricks, is that your residence or not?
Oh, man.
Okay, stay away from that residence. It's not doing good for you.
Yes, ma'am.
Okay, now I'm gonna order that curfew, no guns, and I guess that's it. Yeah, I believe that's it for now. And of course, you'll have to have your mom to co-sign before you can get out. All right, anything else, counsel?
Nothing
Nothing from the state, Your Honor.
nothing from the
Okay.
bench, Your Honor.
Next, we go to position number 6, Mr. Crawford.
This is 24 CR 006076 F, David Crawford. One count of reckless conduct.
Third, 2011 simple assault obstruction. It was NOD. 09 ag assault first offender. This is one.
Okay. State.
Yes, Your Honor. This incident occurred August 9th, 2024. The defendant is accused of firing about 3 shots into the parking lot of the Collier Ridge apartment complex at 100 Noble Creek Drive, Northwest Atlanta. Camila Leonis, the defendant's neighbor, woke up to the sound of gunshots around 11 p.m. Her Ring camera did catch the defendant stepping out of his apartment and discharging the shots after suspicious individuals knocked on his door numerous times. The state is aware that the defendant has a limited criminal history, but that criminal history does consist of only violent arrests or convictions. Given his behavior, there is a concern that he will be a risk to the community at large. Given the severity of the offense, which put lives at risk, it is a blessing that nobody was injured or killed due to the defendant's actions. The state would recommend a $10,000 surety bond, no violent contact with his neighbor Camila Leonis, no drugs, weapons, or alcohol while out on bond.
All right. PD McLean.
That's my case, Your Honor.
Oh, I'm sorry, PD Cook.
Yes. Your Honor, my client is 34 years old. He's lived in the area his entire life. He has worked in the warehouse business for about 9 years. Beyond that, we have no objection to the conditions of the bond, but his income is actually fairly modest. So we would like to keep that surety bond well below the figure stated, no higher than 5,000 surety.
How old? Mr. Crawford is what, 20 something?
34.
34. All right, I'm going to order a $6,000 surety bond. And with that surety bond, obviously no guns or weapons, drugs, unprescribed medication, or alcohol while on bond. If you have any other guns, Mr. Crawford, you need to turn them over to the Sheriff's Department immediately. And no further contact with Camilla Leonis. Stay away from the Collier Ridge Apartments. I'm assuming he doesn't live there. Is that correct?
I think he might live there, but I'll let PD Cook.
If you could, can you ask him?
Well, the address I have where he lives is 2601 Noble Creek Drive. Is that the
I don't
address?
know. I just need to ask him, does he live in that apartment complexes?
Okay.
It could be
Yes.
many different streets.
Mr. Crawford, do you live in the apartment complex they've been referring to?
Yeah, I live there.
I'm sorry?
Yes, I live there.
Do you have somewhere else to go stay since you want to shoot guns in the parking lot? Do you have anywhere else to go stay?
Not at the moment. I'm looking for a new place to stay now.
You are looking for a new place?
Yes, ma'am.
Because maybe with this case, they're putting you out, I'm assuming.
Yes.
They are, okay. So he's got to move anyway, Mr. Cook.
Yes, I understand.
So most apartments, there's zero tolerance when it comes to certain things. I will allow him to move his things out immediately as soon as he can. And he's got to stay away from there, and I'll give him maybe 2 weeks to find another place or move. But if he stays there in these 2 weeks and has any other incidents, he'll be rearrested. Hopefully you won't. And so I'll just give him 2 weeks. He needs to find another place to live. Or maybe stay in an extended stay hotel or something. Because after that, you should not be on those premises at all while on bond. Okay? Guess that's it, Miss Bridgewater.
Next, we have position number 20, Mr. Williams.
How you doing, Your Honor? Ms. Bridgewater.
Good afternoon.
24 CR 006072E, Emmanuel Williams, charged
Yes.
with 1 count of simple battery, family violence. 2nd charge is interference with custody. 3rd charge is criminal trespass. Pre-trial.
4th arrest, 2018 contempt of court. That was out of Virginia. This was a level 1.
Okay.
That's my case, Your Honor. This is an incident that occurred on July the 11th. No, hold on. Yes, 2023. The defendant shares a daughter with a young woman named Kimberly Killens, Killens. During the time of this incident a year ago, the child was an infant. Her name is Kior, Kior, last name Williams. Police responded to 2810 Emerald Court Southwest. That's the defendant's address. There they met with the victim, Mrs. Killens. She reported that she was picking up her child from the father at his residence there. And Mr. Williams refused to release the child to her. They argued. He struck her in the head with an open hand. She told him she was going to call the police, and she went to her car. He then got into her vehicle and snatched her phone from her and hit her again. He refused to give the phone back to her until she came inside to talk. The victim followed the defendant inside. She gathered her things and her daughter, and she went back out to her car. She put her child in her car seat in the back of the car and then walked around to get into her vehicle in the driver's seat. And the defendant stood in front of her to prevent her from getting into the car. He physically obstructed her entry. He then began striking her again. She was able to get into her car, and as she was driving away, he threw her phone back at her while she left. She dropped her child off with someone safe and called 911 and met police at the location. The defendant refused to open the door. They were unable to make contact with him. The victim reported, obviously, they have a child and they used to live together. I would note that at the time of this incident, the victim obtained a 3-month TPO in her favor through Superior Court, and there's been an active warrant for this gentleman. She also requested and obtained an ex parte TPO in April of this year, a second one, and was just awarded a 6-month order that is in place now until November, I believe. We have been in touch with the victim today. She reports that they're no longer in a relationship and they don't live together anymore. She confirmed the information in the warrants and said that this is not the first time that there had been violence. He's been arrested previously, and she obtained a TPO, which I just told you about. She reported that in April of this year, the reason why she went and got another TPO is because, again, they had an argument when they were transferring the custody of their child back and forth. And she was concerned because she saw injuries on her child, and she's been constantly being harassed and communicated with in an ugly way by the defendant. She has requested no contact. Your Honor, we would agree, no contact at this point. We would ask for a $3,000 surety. You've got 3 counts in front of you. No contact with the victim, Miss Killian, or the child, Mrs. Williams, little Mrs. Williams. No drugs, alcohol, or weapons. And no contact until further order of a superior court that awards this young man access and contact with the child. Thank you.
Thank you. The 6-month TPO, were you looking at it, does it include the mother and the child, or just the mother?
Let me pull it up.
Okay.
I can tell you that in a minute.
All right, go ahead, Mr. McLean. Or is it PD Cook?
No, that's Mr. McLean.
Thank you, Your Honor. Yes, I spoke with an attorney. Let's see, did I write down her name? Roslyn, didn't write down the last name. I spoke with an attorney that he had hired last year. And indeed, there was that 3-month, that 90-day TPO. He felt he had complied with everything during that time period and thought the case was over with. There was confusion on his part, I could tell, that he thought that was the case, and he was surprised that there was a warrant. So I explained to him that the TPO is a civil matter, and he understands that, and that a criminal matter is a separate matter, and the statute of limitations, they have 2 years and so on. And so he plans on hiring, I believe, the criminal defense attorney that was suggested to him by the civil attorney that helped him through the TPO of last year. He does work as an entertainer full-time and will hire the attorney or some attorney to come back to the second appearance and to the other appearances, Your Honor. There's no problem with the residences. The court is going to rule in its discretion with regard to the child, since certain legalities have not been followed yet, but I believe she's on the line. So
I'm looking at the order, Your Honor. It says he's ordered to stay away from the petitioner and her children, residence, workplace, or school, and any subsequent residence, workplace, or school of petitioner and petitioner's minor children.
well,
And that's to November of
Yes.
2024? Okay.
there you go. That says it. We would ask, because of his confusion, because of that sort of thing, because he has the ability and the apparently he will make court on time. He hasn't had failures to appear. It was his confusion that made him think he didn't have a criminal case, but he does. We would ask the court to consider a signature bond, Your Honor. He has no disagreement with these conditions being spoken of.
And Ms. Killian is on Zoom, Your Honor, if you have any questions for her.
Yes, Miss Killens. Do you wish to address the court today? If you don't, you can stay off camera. If not, you can come on.
Sure, I can. Pretty much everything that was stated. I'm sorry. Hold on, let me stop. There we go. There we go. Okay.
All right. And do you want to speak to the court today?
Sure. Pretty much everything that
Hold
was.
on. And that was a question of yes or no.
Yes, ma'am.
Raise your right hand for me, and I'll swear you in first.
Okay.
Do you affirm that you will testify and tell the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay, thank you. And so are you in fear of Mr. Williams?
No, I'm not in fear of him, no.
Do you want to have any further contact with him?
No, not at this time. You know, as she stated, there is a TPO in place until November. I think the only thing that I would like to request is that there is some type of anger management.
Okay. And so he's not legitimated your child or anything like that, doesn't have a visitation order.
No,
Correct?
it's verbal.
Okay. But the biggest thing is your TPO doesn't expire to November, so he can't come around you and the children anyway.
Right. Correct.
All right, so I'm going to make my order about the same and not contradict the protective order that came first that says he can't come around. And so those are the only questions I have for you.
Okay.
And the incident location address is where you reside or where he resides?
Correct, where he resides.
Okay, and that's which street is that, State?
It's Emerald Court.
Emerald.
Right. Oh, yeah, the 2810 Emerald Court is his residence. Okay. I'm going to order the $3,000 surety bond. And with that surety bond, it's $1,000 on each of the charges. I'm going to order continued staying away from the residence and work of Kimberly Killings, wherever those addresses are. It's got to be 200 yards away from her. And following the protective order in place, it expires in November of 2024, to have no further contact with Miss Killings and no further contact with her children, which includes his daughter. And no drugs, unprescribed medication, alcohol, or weapons or guns while on bond. And I think that's it. Anything else, counsel?
I think that's it.
Your client is frantically raising his hand, and I said, I don't know. You can tell him. I don't think it's going to be smart of him to say anything.
I'm next door to you, literally a few dozen feet away. I can come back in there. If they keep you in that room, I can answer any questions you got.
All right. That is it for that case.
Yes, Your
Honor. Next we'll go with position number 15. Mr. Norris.
Okay. 24 CR 006065Y. Joshua Norris charged with 1 count of cruelty to children in the third, 1 count of battery, family violence. Pre-trial?
8th arrest. I got a 07 ag assault conviction, 2022 reckless endangerment dismissed. A resident of Tennessee.
Okay.
And that's my case, Your Honor. This occurred on August the 27th at 415 East Paces Ferry Road. That's a hotel. Police were called to the location where they met with the victim, Amy Nguyen, Nguyen. She was seen to have abrasion on her chin and other marks on her face. She reported that the defendant, who she shares a child with and lives with, assaulted her there at the location, and this was done in front of her 3-year-old Miles, who is the victim named in the cruelty in the third degree. He does have a aggravated assault conviction out of Tennessee and reckless endangerment with a weapon arrest and fighting in public in Florida. The victim has been in touch with us. She reports that she is afraid that there's been prior violence, but she has not contacted police before. She does not want to have contact. And so we're asking for a $3,000 surety, Your Honor. It's unclear where the defendant lives. He has criminal history here in Georgia, as well as Tennessee and Florida. And so for that reason, we're asking for a $3,000 surety and no contact with the victim, Amy Wynn, or her child, Miles, Myles Owens, Owens. Thank you.
You said the child's last name is Owens? Or
Owens.
Which PD?
Your Honor, Mr. Norris, has that Tennessee address, but he has contacts here in Georgia and, has so many contacts in Georgia, I think he would be considered local in that he comes back and forth. And I believe, Mr. Norris, if you can straighten us out a little bit, on the contacts you have in Georgia, if you'd speak on that, I think that would help.
My real estate license for the last 10 years in Georgia, Florida, and Tennessee.
And
You have a real estate license in Georgia and Tennessee?
Georgia, Florida, and Tennessee, yes, ma'am.
Oh, a license in all 3 states. Do you have any relatives here in Georgia?
Yes, ma'am.
Who?
I have an uncle and 3 cousins.
Do you have a Georgia address that you
Not a
reside at? No? So you do reside in Tennessee and Florida, I guess, or either or both?
Tennessee.
Tennessee?
Yes, ma'am.
All right, I don't have any other questions.
so I get the impression that if he's got relatives here, when he comes to court in Atlanta next, then he'll probably stay with either a hotel or relatives. Sounds like he has good transportation, he has a professional job. I would ask the court to consider a signature bond on this, Your Honor. Despite the 8 on the cycles, I think he would be a good candidate for showing up in court on time and obeying any court conditions.
I'm going to order a $3,000 surety bond. I'm not excited about the contacts here for Georgia, not that it's as strong. That will be 1,000 on the cruelty, 2,000 on the battery. It's a total of 3,000 surety. Stay away from 415 East Paces Ferry Road. Although that's a hotel, I don't know if the victim is still residing there or not. Have no further contact with the victim, no further contact with, I don't know if it's her child or their child.
I believe it's her child.
Her child. And no drugs, unprescribed medication, alcohol, guns, or weapons while on bond. And I guess that's it. Stay 200 yards away from her.
Thank you.
That's a question, Judge.
About the bond conditions?
Oh, man, just the hotel part.
Mm-mm. I don't know if your attorney's gonna want you to ask me a question about staying away from hotels. Is that somewhere where you reside or something?
No, the hotel that the incident happened, my belongings are still there, so I just need to pick them up.
The hotel is what now?
Has my belongings and my suitcase and stuff still.
Oh, that you need to get from there?
Right.
I don't normally order that the defendant can go back and get them. That's something you're gonna have to work out with your attorney. I usually order for the victim to be able to get their belongings to be safe, but I don't make a habit of that. So you'll have to do that at your own risk.
I just haven't got mine.
We wouldn't object to a one-time police escort, Your Honor.
All right, we can add it to the order that the defendant must get a one-time police escort to go back to the incident location to get his belongings.
Thank you.
Very
Okay.
good. Thank you.
Next, we will go to position number 3, Mr. Blessing.
4 CR 006069A, Derek Blassingame, charged with 1 count of simple assault.
5th arrest. 2023 false statements or writings, false report of a crime, It's 23 SC 190-795. It got open disorderly conduct, 4 counts of simple assault. 22 CR 007-935A. That's all.
Okay. States?
Yes, Your Honor. This incident occurred August 27th, 2024 at 10 Peachtree Center Avenue, Southeast Atlanta, which is the DSU Arts and Humanities Building. The victim in this case is Taylor Middleton, who is an employee of Georgia State, and she's responsible for checking GSU individuals into room 200 of the Arts and Humanities Building and also assisting with their activities. The defendant arrived at the room on the incident date and began asking questions. The defendant got frustrated and agitated and claimed, it's because you hate straight people, I have a right to stay here. The defendant continued to behave in an agitated and hostile manner and refused to leave the room, even when other staff members arrived and asked him to leave. The defendant snatched his Panther ID card from the victim's hand and continued to make claims of discrimination. Our office has spoken with Ms. Taylor Middleton, who is a student at GSU and also, of course, works at the building. She confirmed the events in the warrant, said the defendant is a GSU student, but he goes to the Dunwoody campus. She states that she was told by officers that the defendant was trespassed from the location. She stated the defendant made her very uncomfortable and also took pictures of her. She is afraid of the defendant and she's afraid that he will return to the location. So she wants no contact and wants him to stay away from the location. I will point out that he also has 2 TPOs that were filed in 2024, I'm sorry, 24 CV 008727 and 24 CV 000858. Based on the defendant's history, the state's recommendation is going to be a $1,500 surety bond, no further contact with Taylor Middleton, no further violent contact with any of the GSU staff, stay away from the GSU Atlanta campus since he goes to the Dunwoody campus, and no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for the victim, Ms. Taylor Middleton.
All right, Ms. Taylor Middleton. No, go ahead, PD Cut.
Yes, Your Honor, my client has been in the Atlanta area for about 14 years. He is just finishing his degree. He's in his final semester at Georgia State. We would have no objection to the conditions to stay away and no further contact as long as he can complete his studies at the Dunwoody campus. Just a moment, Mr. Blessingame. Beyond that, he is not working, has no income of any sort. So we would be asking for a signature bond at level 3.
I'm going to order a $3,000 surety bond because there's TPOs in place, obviously. I didn't hear from the state as to when they expire.
So those TPOs are against other individuals. They're not against this
Oh,
victim.
not with this victim. I'm sorry.
Yes, he just has general TPOs that were filed.
Well, that shows he's got a problem.
Yes.
So I'm going to make that surety bond $3,000 because I'm not feeling very safe for the victim here. And no further contact with the victim, Taylor Middleton. No further contact with the staff at Georgia State University on the Atlanta campus. He is to stay on the Dunwoody campus. Stay away from 10 Peachtree Center. And I don't know what his question could be, but you can ask him. No drugs, alcohol, weapons, or guns while on bond. If you have any guns, turn them in immediately.
Your Honor, those TPOs were filed but dismissed because the person did not show up. So those are unrelated to this case, and I don't have any TPOs that are filed against me. Those were filed and they were dismissed. And
Well,
they
but
were,
they usually get the temporary one for a week or two and they just didn't show up for the permanent ones.
they were,
The
they were,
fact, the
they were-
fact that they were, don't cut me off, put your hand down. The fact that they were given the temporary protective order for a week or two, usually 2 weeks before the permanent date, says that there was enough initially to grant those. And yes, I am saying there is a problem because you had 2 of them. Whether they were not made permanent or not does not impress me. The fact that they were even taken out is what I'm concerned about. And I want to make sure that this victim is going to be safe and she won't have to file for a protective order.
all
So
my classes are
I'm not
online.
going to fuss with you. That is my ruling. Because this
With-
is not an exchange between me and you.
No, I just had a question for the board. She does. What is it?
Ask your attorney. Your attorney will call you later.
Okay,
If you have questions about the bond conditions, your attorney can explain them to you.
I had a question about is this a signature bond or is this a?
No, it's a surety bond, good bond.
You guys paid for a bond or something?
Go ahead, have a seat back. Next, we're gonna go to position number 11. Mr. Holmes.
Come on, champ. Is that?
Holmes.
Yeah, I'm about to take you this.
What position is this?
11. 24 CR 00608 Roy Eddie Holmes, one count of battery. Retrial.
31. 2018, fugitive from justice. 2011, suspended license, NOLO. Everything else was much older.
All right, state.
Yes, Your Honor. This incident occurred April 4th, 2024 at 966 Myrtle Street in Roswell. The defendant is accused of striking Shahabuddin Batarafan after a verbal disagreement, leaving scratches and swelling to the victim's face. 2 witnesses, Irvin Riley and Jimmy Pridgeon, observed the parties having a verbal dispute about 20 feet apart, and then the defendant walked up to the victim and struck him. Our office has had a chance to speak with the victim, who states that he manages the property at the incident location and the defendant is a neighbor to that property. A tree that was on the defendant's property fell onto the property that he manages, and he asked the defendant if he could remove the tree, which started an argument. The victim states that during the argument, out of nowhere, the defendant struck him in the face. The victim wants no contact with the defendant. The state's recommendation is a $2,500 surety bond based on the numerous arrest cycles of this defendant, which includes 14 arrests in Georgia, 15 arrests in Michigan, and 1 arrest in Tennessee. No further contact with the victim. Stay away from the incident location. Some anger awareness seems like it would be appropriate since he's punching people in the face for asking him to remove his tree. No drugs, weapons, or alcohol. And I would ask the court to sound for Shahabuddin Batarafan.
Anyone on the line by that name? Looks like everybody left her. Employees, I believe. Is that true, Ms. Lewis? We don't have any outside people, or who is
Yes, we
Ruby
do.
Moore
Yes, we
Washington?
do. We have 1.
Which case is this Ruby Moore Washington here for?
I have no clue. Have to ask her.
Ruby Moore Washington? All right, we'll keep going. Okay, ma'am, which case are you here for? Can't hear you.
She's unmuted, but I don't know if she know how to work her camera.
I may not need the camera just to see what case she's here for. Do we only have 1 more, I think? I don't know, 1 or 2 more. Okay, I will get back to this case with Mr. Holmes.
Your Honor, that's my case.
Yeah, go ahead.
My client has been in the Metro Atlanta area for 24 years. He has a tree service. He has been working that for 18 years. He disagrees completely with the allegations as stated in the warrant. His position is that the alleged victim came onto his property, charged him, and started the altercation, and he was acting in self-defense at the time of the incident. We would be seeking, therefore, a signature bond at whatever level the court deems appropriate. We have no problem with a no further contact with the alleged victim. I'd have to get again, refresh my memory on the actual location because it could actually be my client's property that this occurred at.
966 Myrtle Street.
Is that your property, Mr. Hill?
Roy Holmes, no, that's not my property. That's where he lived. That's the property he manages, but that's not where it took place at. It took place.
Stop. We only asked one question.
Okay, I'm sorry.
Go ahead. Are you finished, PD Cook?
Yes, just wanted to make clear that the incident did not happen on your property, Mr. Holmes.
Oh, it did not.
Okay.
Is that it?
That's it, Your Honor.
Oh, okay. I'm going to order the $2,500 surety bond. And with that surety bond, there's going to be a stay away from 966 Myrtle Street in Roswell. No further contact with the victim. And I don't know how to pronounce her name. The property manager at the adjoining property. No drugs, alcohol, weapons, unprescribed medication while on bond. And I think that's it. That's all.
Thank you, Your Honor.
Thank you.
Next, we can go to position number 13, Mr. Moham.
This is 24 CR 006073Y. Kenny Mohammed, charge of 1 count of theft by shoplifting.
This is a bind over case, Your Honor. And it's
All right. Pre-trial, I'm sorry.
You want to hit his bond over? He got bonds?
So it's already.
I'm not sure.
Okay, let's see what ASG Allen has.
I don't know why these bond overs keep hitting the calendar.
Yeah.
It's strange.
His booking sheet is at 1,500.
Your booking sheet says what?
1,500 surety.
Your Honor, this is an incident that occurred at a record store on Alpha.
Well, hold on a minute.
Highway.
Do I need to hear it? He has a bond.
We would like a condition, otherwise, no.
Oh, okay. Well,
It is a year old. I would like to ask them over the bond to a signature.
well, go ahead, State.
The allegation is that he took more than $200 worth of vinyl records from a record store on Alpharetta Highway. He was recognized from a previous incident. He was identified through the use of his credit card. He actually bought one record with his credit card and then went back to the location where the records are and was seen putting a big stack of records underneath that one record he bought and walking out without paying. He was also identified through his car. He returned to the location and spoke to police and denied taking any of the items. And he had been issued a criminal trespass, actually, or was on that day. We just asked that he be told not to return to the location. It is Second Chance Charles, I think is what the store is. 10723 Alpharetta Highway.
Okay.
Your Honor, that's
PD
entirely.
McLean.
Am I unmuted?
No.
Okay. That's entirely appropriate to stay away, Your Honor, because the case is a year old. I would ask the court to consider a signature bond. He has an address in Decatur. He has a phone number. He has an emergency contact to his sister. And says here the last arrest was 1995. Is that correct?
Suspended license.
Right.
Correct.
So on since this is a shoplifting and it's not a felony, this must not be his fourth. So for all those reasons, I would ask the court to consider a signature.
I mean, Judge, I'll take him if you want. The last arrest was 95 since we
Okay.
hearing the case. So.
Well, I'll give him a $2,000 signature bond through pretrial level 1. And stay away from the record shop, Alpharetta Highway. No further contact with the employees there. And no drugs, unprescribed medication, alcohol, or weapons while on bond. That's it.
Thank you. Good luck.
Next, we go to position number 18, Mr. Wiley.
Whatever you do.
Said 18.
Yes.
That should be our last case, right?
Yes.
Okay. And did the other person, they got off, didn't they? Of the Zoom?
Yes, she did.
I don't see her, huh? She
Yeah,
closed out.
she did get off.
Okay. All right, 24 CR 00607 4D Adidas Wiley, charged with 1 count of simple battery against police officer, 1 count of willful obstruction, 3rd count of possession of marijuana less than an ounce. Pre-trial.
24. 2023 FTA on probation for simple battery. It's 23 CR 004 698D. 2018 FTA. Trespass conviction. 2017 trespass conviction. I think he's homeless, according to the booking. That's all.
Your Honor, this is my case. 1 second. Law enforcement were called to 2848 East Main Street in East Point. There, at the MARTA station, the defendant was seen smoking a blunt. The officer smelled the blunt. She approached the defendant and asked him about what he was doing, let him know that he was in violation of the rules. He was on the MARTA platform at the time. Officer Taquania Howard with MARTA Police, this was just yesterday, August the 27th, directed the defendant to hand over his blunt and his ID. He was told to put his hands behind his back, and he was being detained when he physically pushed this officer. So he's charged with the simple battery against a law enforcement officer, obstruction for failing to follow directives, and possession of marijuana. It looks like he's got an open probation case for simple battery. His convictions and criminal history since 2006 all involve drugs, disorderly behavior, criminal trespass, shoplifting, and some forgery. We'd ask for $1,000 or surety bond, Your Honor. No MARTA. Stay away from MARTA. No drugs, alcohol, or weapons.
All right. PD
Oh.
Cook.
No, it's fine.
Oh, McLean.
We do understand that's certainly within the range of reasonableness. The range might also include the notion of a signature bond. He is residentially challenged, but he does have a phone that he keeps on. And he also has his mom's address. I'm sorry, mom's phone number. I don't have her address, but that's simply because I didn't ask it. I've also got his dad's phone number. So because he's local, he's got family contacts. Despite him being residentially challenged, I'd ask the court to consider both ends of that range of reasonableness. Perhaps give him a signature bond at $1,000. Sure, he's not too bad.
I'm going to give him a 2,500 surety bond. 1,000 on the first 2 charges, 500 on the third. Ask him to stay away from MARTA. No drugs, alcohol, weapons, or guns while on bond. And I guess that's it.
Thank you.
Mm-hmm.
No.
Yeah, Holly, we ready.
Ms. Bridgewater,
Okay.
since you had a fan today.
Oh, boy.
I was like, who told him to say hi to Miss Bridgewater?
That's why I turned my camera off, okay?
Right,
I'm
right.
Why did you have it on?
She does
She
sometimes when
can't
she's
help
at
if she's bewitching. Come on.
I'm just
now.
asking. I'm just asking.
Every now and then I pop on and let you all know I'm still alive over on this side.
right.
Boom, what
And
happens
and,
when I put it on?
and Tucson, she was getting a date, a solicitation, or what?
I don't know what it was.
Y'all too funny. But anyway.
Well, you heard he was an entertainer full time.
Well, this is true, so I don't know, right? Okay.
Y'all still on YouTube. Can we go forward?
Oh, we're sorry.
Yes. Once
Stop the recording.
stayed on
Are
the
you stopping the recording for the when we reconcile, or is the
No, it
reconciliation?
has to be reconciled on YouTube. I'm ready. Let's go.
Oh, it does. Oh, sorry. Okay, thank you.
Right, with that being said, our reset date for the SAP calendar is September the 10th. Position number 1 is reset further notice with a $3,000 SOB through the jail. Position number 2 is going to the SAP calendar with a total $4,000 good bond. 3 SAP calendar with a $3,000 good bond. 4 is reset further notice with a total $5,000 SOB through pretrial. 5, reset further notice with a total $5,000 SOB through the jail. 6, SAP calendar with a $6,000 good bond. 7 is reset further notice with a total $4,000 SOB through pretrial. 8 is going to the SAP calendar with a $4,000 total good bond. 9, reset further notice with a $5,000 SOB through pretrial. 10, SAP calendar with a $2,500 good bond. 11, SAP calendar with a $2,500 good bond. 12, reset further notice with a total $4,000 SOB through pretrial. 13, reset further notice with a $2,000 SOB through pretrial. 14, reset further notice with a $2,000 SOB through pretrial. 15 is going to the SAP calendar with a total $3,000 good bond. 16, reset further notice with a $5,000 SOB through the jail. 17 is going to the SAP calendar with a $2,000 good bond. 18 is going to the SAP calendar with a total $2,500 good bond. 19, reset further notice with the $2,000 SOB through pretrial. And position 20 is going to the SAP calendar with a total $3,000 good bond. Are there any questions, comments, or otherwise?
What's number 6 again?
Number 6 will be, I have it as a $6,000 good bond.
Okay.
Are there any others? Okay, well, same place, same time tomorrow, okay?